This is Dr. David Schein, and welcome to Business Law 101. Now, I always put in a pitch for our students to appreciate the fact that you do care about wills. So even if you're very young, you have a young family, or you don't have any children yet, you have parents and grandparents who should have wills. And it is very, very sloppy to have a person die intestate. Intestate means they died without a will. And it's a very sad situation because it turns your personal life into a judge's situation. And the judges are liable to appoint a buddy of theirs as a person to be a curator of the account or custodian of the account. And they're going to bill that to the estate, and it's a very sad set of circumstances. So the guardian is a person appointed to look after minors. That's a pretty common use. Testator is the person who's died leaving a will. Now, I want to point out that some of you may have heard the term testatrix, a fairly unattractive word that referred to a female testator. One of the things we've done to clean up and to avoid gender identification is testator is one of the words that we now use for both men and women, just as we today use the term actor for male and female performers are often referred to as actors rather than actors and actresses. Two other key terms: the executor is the person who is appointed to administer the estate in a will. If the person dies intestate, there is an administrator appointed by the court. Now, keep in mind, again, many people wrongly assume, well, gee, if my mom dies, I'm the oldest son, I'll be appointed administrator. So she doesn't have to worry about a will. It'll all go by legal statute. Don't be so quick about that because, again, they're still going to appoint an attorney. The attorney is going to bill your estate by the hour, and it can be a very expensive proposition. The average for somebody dies intestate here in Harris County is about $2,500 in legal fees paid to the court-appointed administrator, the attorney appointed by the city. Another page of definitions: a devise, a bequest, a legacy, and specific gift. Now, these definitions have largely failed over the years. So devise is a gift of real estate, bequest a gift of personal property, legacy a gift of money. These first two are rarely used today in terms of day-to-day life. We don't worry about the distinction between a devise and a bequest and a legacy. It's just, hey, I inherited something from grandma. I'm happy to have it. I don't care which of these three words applies to it. So we've become a little less concerned about some of these definitions, but I just wanted you to be aware of where they came from and how they're used today. General gift is specified sum of money, and what happens in that is that it's just the property. So, for instance, somebody dies and says, half of all I have goes to my wife. The other half of all I own goes to my 7 children in equal parts. Just hypothetical. And a residuary gift is anything that's not specific or general devises. Anything that's left over is a residuary. So that's pretty easy. Now, if you're executing a will, you must have the capacity to enter into the will. We usually require age 18 at the bottom end, and we don't require people to be, super, super sharp. They don't have to win, would you like to be a millionaire or something, or Jeopardy, and show all your great mental acuity. But you need to be reasonably with the program so that the person notarizing the will doesn't look up at the person and say, I don't think you know what day it is, or I don't think you know where you are. You can't have a will under those circumstances.